instruction. Instead of propagating falsehoods, the NPA must investigate and prosecute the case referred to by the TRC. If memory serves, the case that the former president refers to is maybe the Rodriguez case. But that case was about a permanent stay of prosecution. One can ask, what would the president's business be in that case for intervention? It's different from a case like the present, where the relief is to declare that conduct he committed breached the Constitution. That's a completely different kettle of fish. But they want this court, when it determines the merits of the application, to simply lap up and accept what was the findings that were made in Rodriguez, the comments of the journalist, the comments of the writer, and the like. At 404, they say, Mbeki claimed that he and his administration always acted in accordance with the Constitution, and he called on the NPA to demonstrate integrity by apologizing to victims for not prosecuting the TRC cases. In brackets, conveniently, some people forget that the ANC, they are quoting me now again. Conveniently, some people forget that the ANC was the principal architect of the Constitution of the Republic. During the years when I served as Deputy President and President of the Republic, I, together with my any NDPP to act in any other way or another. No NDPP, including Pico, ever approached me to complain that he or she had been instructed by a minister or any other official to violate the independence of the NPA as prescribed by the Constitution. The NPA must demonstrate enough integrity by apologizing for not processing the TRC cases rather than engage in dishonorable behavior of trying to hide behind a fig leaf, which is nothing more than pure fabrication. What do the applicants say? The denials of former President Mbeki are not consistent with the brazen suppression of the TRC cases that occurred during his administration and which has been set out above. The chapter and verse read, it is for an independent commission of inquiry to consider and test the veracity of the denials of former President. But they don't agree to stay their proceedings pending the commission of inquiry. They refuse. They are opposing the stay application. And they're refusing President...
Just on that point.
Yes, ma'am.
If one took the view that the Commission of Inquiry all will be revealed, your client will testify before the Commission, Ms. Mabandla will testify, many others will testify, and there will be an outcome. That doesn't bind anybody. It only helps your client, at least, if the Commission of Inquiry vindicates your client. And then your client would say, you see, I told you so. But if the Commission of Inquiry doesn't vindicate your client, then we're back where we are now,
yes,
which is the applicants in the main application seek the declarative and seek damages.
Yes.
Now,
It is 100%
it would be easy if everyone agreed to postpone everything until after the Commission of Inquiry, because then all will be revealed.
Yes.
But if that's not to be, then one must deal with the case as it is now,
Quite.
and with the papers as we have them now.
Quite. And there are two responses we make to that. Is, my lord is absolutely correct. If they say we're proceeding with the application, then for the very reason that they poo-poo what former President Mbeki says in the quoted passages here, that he did not intervene, and the conduct that they attribute to him cannot be found correct by this court. Why do they not want him to come and show that the journalists and the writer are incorrect and the basis of the relief, as far as the government is concerned, relating to the conduct of his administration, is incorrect, and to that extent that relief can't be granted. Why don't they want that dispute ventilated in an open court in terms of Section 34 of the Constitution? Because there is a dispute. We dispute this allegation, and I'll demonstrate in the founding affidavit in the intervention. But other than, unlike what they say about us, they say, well, in reply, we scurry around to say we have a dispute with this applicant. We say so in the founding affidavit that there is a dispute regarding these allegations, which are the foundation of the application.
And your client's interest, as I understood it from the founding affidavit, it is so, as Mr. Chastelson says, that there's no specific assertion that we say that no relief should be granted and we oppose the relief. What's opposed is the finding, which is a precursor for the granting of the relief. So the fact that the government may ultimately be ordered to pay money as constitutional damages isn't the issue here. It's whether your client's wrongful conduct is the proximate cause for that payment. It could be that others have done it, committed wrongful acts, which would ultimately yield a successful outcome if the net was cast wider. But in this case, the net is it's a small net, and it's called specifically two persons within it.
Yes.
And their case is predicated upon that. But you don't say, well, we say that there's been no delay, because factually everyone can see there's been a delay.
Yes.
And factually everyone can recognize that these families have been wronged.
Yes.
In terms of the consequence of 30 years of inaction and failure to get to grips and bring these matters to a conclusion.
Yes.
There's no dispute with that. It's a question of whether or not your client deliberately played a role to bring about that situation. He
Yes.
says he didn't.
Yes. And my Lord, if we only look closer on the relief in the declarator, which now helpfully sets a time frame. So my client's dispute of the allegations and its impact on the relief will impact the duration of that interference and will affect the period that will be stated in the order. So the court might say the declarator is issued, but doesn't include the period when my client was head of the administration, where the conduct relies on him and his administration. So there is a direct impact on the relief, on the order that is being sought. Directly, there is a direct impact. Yes. And my Lord was correct earlier to say, well, we can wait for the Commission of Inquiry, but the Commission of Inquiry's findings and recommendations are just that. They won't be binding on court, but they may reveal the truth. They might say, well, having seen what came out of the Commission of Inquiry, we limit our relief to certain periods. That's for them. But the court will still have to make the final determination on whether there was a breach by my client's conduct for a period of time. Even if the Commission vindicates, they might disagree with the Commission and still come to court. But at least and it's important, we touched it in terms of reference of the Commission. It makes it clear that parties to this litigation are interested parties in the Commission. So if my client is a party to this litigation, he will be party to the Commission, he will testify before the Commission. So it's very important from the discussion, the debate we just had, my Lord, when I go to the law, to bear in mind that we are saying that we are in the weighing category, where the matters that we complain about are issues in this case, and that what we are going to say will affect the outcome and actually the formulation of the relief itself as far as the declarator is concerned, and will have an impact on the extent of the damages, because that, by any definition, would have regard to the duration, because the duration is linked to the extent of the harm.
But your client's
It's not
interested.
It's not interested.
Other than the period for which he is said to have been the proximate cause
Right.
for the harm.
Right.
You see, like, during my tenure, it didn't happen that way.
Right.
It may have happened following on from me, but not while I was the guiding mind for the state.
Yes. And he may be disbelieved by us, but Section 34 entitles him to come to court and have that dispute ventilated in an open and public hearing. Then you'll see, my Lord, at 001-171, they then talk about the period post-political interference, and that relates to the question my Lord asked about, well, what happened afterwards. I think there was some reopening of inquests on applications and the like. But that doesn't concern my client directly. What I need to take my Lord to is, what do they make of all of these allegations that I've just been through? They draw them together under the violations of the law, and you will find that at 001-217. They told you the story, and they say, violations. I'm advised that before I set out the basis for the relief we seek, I must set out the statutory and constitutional provisions that have been violated by the political interference that resulted in the suppression of most of the TRC cases. That interference they've already described. And then they say 528, any agreement or arrangement not to hold to account and punish those who have committed the most heinous of crimes is at direct odds with the most basic feature of South Africa's constitutional order, namely the rule of law. You will recall they say the agreement arrangement involved my client with the generals and former President de Klerk in exchange for immunity for the generals. 529, those who impose their will on the NPA and the SAPS not to stop or undermine the TRC case from proceeding, as well as those within those organizations who are acquiesced to these demands, violated multiple constitutional and statutory provisions. These are set out below. So they are directing that to people, you and I, flesh and blood, those who impose their will. These are my clients. During their time, they violated multiple constitutional and statutory provisions, and they set them all out, the statutory provisions, some involving criminal conduct, especially breaches of the NPA Act. And then they say at 001-219, paragraph 530, every constitutional and statutory duty and obligation mentioned above was violated by those who imposed their will on the NPA, and as well as the NPA leadership and its senior staff members involved in the abandoning of the TRC cases. Although the NPA enjoyed exclusive authority to institute criminal proceedings on its own version, it allowed others to impose their will on the authority to stop prosecutions that otherwise would have been pursued. Who are those who impose that will? It is my clients in their administration and those members of that administration. 001-220, 530.2, the government officials and executive members who imposed their will or attempted to impose their will on the NPA, and the NPA leadership and its senior staff members involved in the abandoning of the TRC cases violated Section 32(1)(ab) of the NPA Act. Executive members, they've mentioned Minister Mabandla and the letters she wrote, the President and what he did, and suspending Mr. Pikoli from office because he wanted to pursue TRC cases. The responsible officials also violated their oaths of office in terms of Section 32(2) of the NPA Act and Section 41(1). So they've drawn the allegations to the, and then they say on page 001-222, they say 537, the last sentence, the actions of the responsible persons, both within and outside the NPA and SAPS, warrant investigation into whether their conduct violated those provisions. And then they say grounds for declaration and constitutional damages. 538, the suppression of the TRC case has been almost total in its impact. Virtually all the approximately 300 cases referred to by the TRC to the NPA were blocked from proceeding from around 2003. This suppression lasted for a period of at least 15 years. Its effects are ongoing. The impact on the families of those murdered, their communities, and on the fabric of society is incalculable. denial of justice. The bulk of the apartheid era cases have come to an end because suspects and witnesses have died, not to mention family members. The primary reason behind this monumental failure of justice has been the political interference which effectively killed off the TRC case. Those behind these machinations knew that this would be the outcome. They must be held to account. Those are my clients. Those, they are not talking about schemes in vacuum, they're talking about those who did these things. And then they carry on, my Lord, if one looks at 001-236, paragraph 566, the conduct of the responsible officials behind the interference has denied us justice within a reasonable time or at all. In so doing, they have exacerbated and prolonged our pain and trauma. We have been denied the possibility of closure of our most painful past. This conduct has breached our rights to human dignity. Those responsible officials include my clients. And they say, and they talk about the various violations, but it carries on, it's the same thing. And then they draw it completely now to conclusion 001-240, 577. They say, in the circumstances, I have set out sufficient grounds to warrant the declaration sought in the notice of motion that the interference violated the rule of law as well as our fundamental rights, was in breach of duties and obligations in terms of the Constitution, the MP Act and the SAPS Act, was inconsistent with the principles, values and obligations arising from the TRC process, was inconsistent with South Africa's international law obligations. I submit further that I have demonstrated sufficient grounds for the granting of constitutional damages in the amounts which are set out below. The basis, they tell you, is the political interference by those responsible in the executive and the NPA. They've said themselves, how now can they say the court doesn't have to decide those issues in order to determine their entitlement to relief? With respect, it is just doesn't bear scrutiny at all. But they are asking this court to make that determination when it is not this court that's deciding the merits. But the court can see, how does a court properly applying its mind to whether the relief is made out, other than to make factual findings on this allegations and determine whether they resulted in interferences and a violation of the law. So those are the facts they say in the founding affidavit, in their founding affidavit. The next topic I need to deal with is I must deal with the law. When I dealt with the law, I didn't take my vote to the Maria judgment, because that's the first judgment on which we rely, which is must be considered together with the Wayne judgment. So, my Lord will recall that in Maria, this was a witness who had given evidence in a trial in the mesh court where he was not a party. And there were adverse findings, credibility findings made against that witness. And the party to the litigation against whom the judgment was rendered didn't take the judgment on appeal. And he sought to intervene in order to bring an appeal against the judgment. Those are the facts. And you can see they're wholly different from this. They're similar to Zuma, NDPP versus Zuma, where findings that you made, credibility findings, you are outraged by them, rightly, and you want to have them reversed on appeal. And in those cases, the courts were very clear that such a witness is no standing, because whatever they say has no impact on the order. They're not challenging the order in any form or shape. In fact, what they say may not even determine the outcome. And that's very similar to the case that's been handed up, that's going to be handed up involving Mr. Koko. This was a review application. They made findings he didn't like, and the court could demonstrate that if you go back to the judgment, you'll see that nothing was said about your conduct. So the facts you want to put up have no relevance to the determination that must be made. But that is a completely different case from the present one. And here, my Lord, the first thing I want to refer the court to in Maria, I can't recall whether that has been uploaded on Baselines. We were meant to upload it, but I'll just refer the court, the first is paragraph 17 of that judgment. There the Constitutional Court is dealing with jurisdiction. And my Lord knows that the Court will take a matter if it raises a constitutional matter or a legal matter of such public importance, which is arguable. So they had to ask whether they had jurisdiction first to even hear the appeal. And this is what the court said there is important because the rights they mentioned there are the rights my clients rely on here. They say at 17, in this case, the applicant seeks access to this court in order to challenge on appeal a finding made against him by the magistrate's court which adversely affects his right to human dignity. This means that this case implicates both the right to human dignity entrenched in Section 10 of the Constitution as well as the applicant's right to have any dispute that can be resolved by the application of law decided in a fair public hearing before which is entrenched in Section 34 of the Constitution. And that's exactly what we want to do before this court, is to ventilate our rights. Then the court turns to the merits, discusses that, and the first point, the first reference I want to refer the court is paragraph 22 of the judgment. It says, counsel for the applicant sought to argue that there was a link between the order by the magistrate's court and the adverse credibility finding made against the applicant, which gave him a direct and substantial interest in the order. However, the position is simply that even if the applicant were to be allowed to intervene, there is nothing to do with the order that the court made against the second respondent. That order gave him nothing and took nothing from him. That's different. This order is going to find that conduct by my client breached the Constitution and warrants a declarative. My client is a wrongdoer. So the judgment will take something from my client. There will be an order read with the judgment, because the judgment will provide the basis on which the order is given, and that judgment will traverse these facts and make findings that during his administration there was conduct which interfered with TRC prosecutions, of which he was the architect, because that is what they say. He opened the door to political interference and executed that. So just on that, our clients, what the client is bringing will impact the order, the duration, period covered in the order, and even whether the order is given to the extent relating to the period of his administration. That's the first part of our case. That gives us direct and substantial interest in the subject matter of the judgment and the order that the judgment will grant. It doesn't matter that the order is not sought against us. That is not the test. The test is not you can only intervene if an order is sought against you. It is whether the order will impact your rights. That's a different question. It's a more substantive question. And then the Constitutional Court turns to what we say is the second basis on which we rely. And that is the Wayne category in paragraph 23. It says, the applicant placed some reliance on a statement made by Adelson J. in Wayne, where the court said, where there is an attack on the character of a person who is not a party to the litigation, it is conceivable that there may be a limited right to intervene, provided that it will be essential for the purposes of the judgment that the correctness of such attack be considered and decided as part of the court's reasons for determining the issue between the parties. Then the applicant's counsel also relied on Nahapa, where the court approved the passage from Wayne, and the court's, that passage says the same thing. The allegations you complain about must be essential for the court's determination in its reasons. And then he also referred in paragraph 24 to Wayne. That's still the same point. In that case in Wayne, because there was no more lease, because the main party wasn't appealing, that was also another basis to deny standing, because whatever he says would be unhelpful to the court, to the judgment. And there are other cases where, in one case, there was a settlement already by the time the disappointed witness wanted to intervene.
Yeah, the dispute is still live.
Very much live. And paragraph 26 refers to the Zuma judgment, where they say, and that's the case involving my client, which our learned friends always hit us with that, and they see we are coming here to do exactly the same thing, when we genuinely are not. We may be misunderstood, but we are not doing the same thing.
But even if you would, in each case, if you look at it on its own face, its
own merits.
No, I couldn't say
This
that.
case is distinguishable because of the fact that it's still live.
It's the
It's not proceeding an ex post facto attempt at vindication.
Yes. My learned friends will say, well, that principle applies whether you come and appeal or you come in first instance. If you're just a witness worried about your reputation, but what you say will not impact the determination, you mustn't come in. But we say, what we say will impact the determination. Their answer I'll show, my lord. Maybe at this point, let me show, my lord, what their direct answer to this is. Because it's in paragraph 39 of the, and I'll come back to it's paragraph 39 of the heads of argument. After quoting from Wayne, they quote from Wayne. They don't say Wayne is wrong, was wrongly decided. They apply Wayne and say we are outside Wayne. They say this is the nub of the problem for the intervening applicants. 39.1, the court deciding the declaratory relief and claim for constitutional damages can give judgment on the merits without deciding whether the intervening applicants have personally committed any crimes or transgressions in relation to the TRC cases. I don't know what they envisage. So the court will say, I can ignore all the chapter and verse you've said about the conduct of the Mbeki administration, and I can still find that there was a scheme to interfere with TRC cases. And there is your declarative, which declarative speaks of conduct over a specific period of time. It may not have to say you have committed a crime or a transgression in relation to the TRC cases. Well, it may not say you've committed a crime. We're not saying that's what the court is going to say. But certainly it will say, in relation to the TRC cases, you interfered with prosecution, and your interference breached the Constitution. In consequence, we can declare that this government has breached the Constitution because this government inherits that. But they have to determine what they say. Why did they say it if it doesn't have to be determined? Over so many pages with so many annexures. And generally speaking, all left, right, and center.
Well, if the claim had been formulated on the basis that there was no reference to any individual,
Yes.
would a court be able to find damages in the absence of any allegations of wrongful conduct on the part of anybody? I mean, there has to be someone responsible for the breach of the right.
Yes. And my lord, that's someone.
There may be a breach of the right which occurs in consequence of circumstance where there's no one person responsible. That's not actionable in the way that they seek to have it actionable here with the payment of money. Those are cases where, well, you've discovered a breach of rights, there's no one that's specifically responsible, but the remedy is to put an end to the breach. It's not the damages contemplated in Section 39.
My lord, the very prayer that they're pressing this court to give speaks of conduct. Conduct is perpetrated by persons and constitutes of acts over a period of time.
Or omissions.
Or omissions over a period of time. And those persons, my lord, must have the capacity to interfere with prosecutions and must interfere, which is what they say. So you need to have all of that. You can't just say there was a scheme where, by whom, over what period, constituting of what steps. And knowing that they've given the court chapter and verse of that conduct, they can't now suddenly say, well, that the court can reach a conclusion without regard to that. And then they say in 59.2, the court does not have to find that Mr. Mbeki was responsible for the interference or even connected to it to give judgment on the merits of the family's relief. I don't understand how that is possible. Because there is an administration. The administration is an artificial concept.
The court was removed to stop it.
Exactly.
From pursuing that.
Exactly. The
It's
administration.
clear and unequivocal.
Yes.
Reference to your client going into his study and writing the letter himself.
Absolutely.
It doesn't get more
proximate and direct than that.
Absolutely. And the administration acts through officials. So it's an artificial construct. And then they say in 39.3, the court may only consider whether there is sufficient evidence in the record before it of a scheme, plan or design to undermine or abandon the TRC cases. Oh, well, it could have been a plan by somebody sitting at some restaurant. That wouldn't be of interest to this court, who is not an occupant of an office in the administration. That would be of no interest. There's sufficient evidence of the scheme, plan, or design. The plan, scheme, design is acts by individuals, planned, executed with consequence, which constitute a breach of the Constitution. Then they say in 59.4, this court, Honorable Court, does not have to make findings of individual responsibility. We are not saying the court is going to say, Mbeki, you're responsible. But it's going to say Mbeki's conduct on the invitation breached the Constitution. So when they talk about personal culpability, we're not going to that extent. We're not saying at the end of the day when you list individuals in this, the order is so and so is culpable and like. You're going to say the conduct of who in read the judgment of these individuals, which were set out in the founding affidavit, uncontested by those implicated, justify the conclusion that there was a breach which justified declarant. There is no, this is really the height or form of a substance. The substance is there, and these applicants can't now walk away from it on the basis simply that they want to keep the door shut to my clients. If we go back to Libya, I had referred to the Zuma judgment that we are not in that situation. What the court then concludes on the facts at paragraph 29 is, I do not think that the decision in Wayne can assist the applicant in any way. This is more so in the light of the clear position that his interest is really in the adverse credibility finding made against him, and not in the order that the magistrate court made. Furthermore, the fact is that there is no list between the parties anymore, just as there was no list between the parties in Wayne. In this case, the MEC accepted the judgment and order of the magistrate's court and satisfied the judgment. It must also be remembered that there is no appeal against reasons for a judgment, and an appeal lies only against an order. This means that even a party to litigation cannot appeal against any adverse credibility finding that the court may make against him or her if in the end the order that the court made is the order that he or she wanted, or he or she has opted not to contest the order. A defendant who succeeds in getting a court to dismiss the plaintiff's claim cannot appeal against one or other adverse credibility finding that the court may have made against him or her in respect of one or other issue in the course of this judgment. So the court doesn't say Wayne was wrong. It says Wayne is not satisfied. So we submit that Wayne remains, that category remains good enough, and that category justifies my client's intervention as a second leg for why the intervention should be granted. And you'll see that in the reasoning of the court on why one doesn't develop the common law is because the common law already has the Wayne category, which caters for people like my client who are not named, cited directly, against whom no specific relief is sought, but the relief impact on them. And they are able to dispute the allegations and place matters before the court. What I need to do, my Lord, is to show, my Lord, briefly in the application for intervention, what my client said was the basis for intervention. What they said was why they have a right, and that, my Lord, will find in the founding, well, the notice of motion is 004-4. In paragraph 1, they ask for intervention as 7th and 8th respondents, and that they will be served with the papers, the full papers, and that they will be directed to file answering affidavits in the time period that this court will permit. And we've tried to explain that might, in the case management meeting, the case is being case managed, the case management meeting will determine the duration.
So you say, if I'm with you, we discuss this with Mr. Justice, and this foreshadowed in our discussion in chambers, that perhaps the question of the time periods for the filing of papers, if the intervention is granted, be referred for determination at a case management meeting.
Yes, we get to them. That is
Would that be the appropriate? I'll hear from Mr. Chastity.
He's nodding, but I
He's
can't
nodding
nod him
back.
to the north. But
The microphone doesn't pick up the nodding.
Let's pick up the nod.
If I can convert the nod into a yes.
Okay.
And my Lord, I've already referred to, in the founding affidavit, it starts at 004-13, and you'll see there's set out the purpose, which refers to the summarizes the relief, and then discusses the different categories of TRC cases. And then paragraph 12 sets out the duration of their term, paragraph 12. And paragraph 13 says the relief the applicant seek is underpinned by, the main applicant seek is underpinned by allegations of unconstitutional and criminal conduct by me and Ms. Mabandla during our tenure. I've taken the court to that. Given the nature of the direct challenges made against Ms. Mabandla and I, which underpin the relief that the applicants seek, as well as the orders that they seek, Ms. Mabandla and I seek relief to intervene at 7 and 8. And they rely specifically on the broad standing in the Constitution, because they say that their legal rights will be adversely affected if they are not allowed to intervene. Section 10 and Section 34, I've referred to the Revere judgment that accepted that. And they, Section 38C, they can represent members of the administration and also the public interest, because this is the public interest. Then they say, paragraph 16, in summary, the direct and substantial interest that Ms. Mabandla and I assert arise in the following circumstances. 1. First, the serious allegations of unconstitutional, unlawful, and criminal conduct against Ms. Mabandla and I, as well as the members of the administration of which I was president, are issues between the parties in the litigation. That's the weighing issue. The court must determine the issues in order to grant the Calata applicants the relief that they seek. Those allegations are highly defamatory and damaging of our dignity and reputation. The applicants tend to suggest that all we want is to come here to defend ourselves against defamation. Now we're just saying these allegations, which are serious, which are issues before the court, are also defamatory of our clients. Our character is beyond all price. All these judgments say that. In such circumstances, Ms. Mabandla and I are entitled to intervene to dispute the allegations and serious and damaging allegations made, and to place direct evidence before this court for it to determine the correctness or otherwise of the serious allegations against us on which the applicants rely for their relief. 1. Second, and these are independent bases for intervention. 16.2, Ms. Mabandla and I dispute that we or the administration of which I was president interfered with the NPA's prosecution of TRC cases and committed unconstitutional, unlawful, and criminal acts as the Calata applicants allege. We intend to place relevant direct evidence before this court to oppose the allegations on which the Calata applicants seek relief, and to have legal submissions made on our behalf in that regard. Denying us intervention in such circumstances would conflict with and unjustifiably deny us our right under Section 34 of the Constitution to have this dispute, or disputing these allegations which are the basis of the relief by the applicant, resolved by the application of law decided in a fair public hearing before this court. Once we are denied the right to intervene as respondents and defend ourselves against the serious and damaging allegations, we would not be able in future to relitigate the findings of this court against us. It is unlikely that a court of appeal would allow us the right to intervene to challenge any adverse findings by this court if we are denied the opportunity to defend ourselves as respondents before this court. I'm advised that there is authority in the highest court in the land that a witness who was not party to proceedings may not seek to intervene on appeal to challenge adverse findings against him, or where he or she does not challenge the order that the court of first instance is granted. He is aware of the Zuma case and the Revere case. Third, Given the allegations of intentional interference with the NPA and the prosecution of TRC cases for alleged personal interest or private organizational interest, the government, represented by the first, second, and fifth respondents, may contend that this court must find that if there was unconstitutional, unlawful, or criminal conduct by Ms. Mabandla in the administration of which I was president, it is conduct that is contrary to public interest because the government and the public have an interest in protecting the rule of law and ensuring good governance. If the,
Can you just hold this? Pause there. I was going to ask you, and Mr. Chaskas also, was not a possible solution to the matter that your client proposed to an affidavit on behalf of the government parties to obviate the need and to put their version forward? But you answer it here.
yes,
Where you say, well, there may not be a confluence of interests and there may be contradictory positions which get taken subject to what comes out in the wash.
Right.
So it's not as convenient as simply saying, well, you used to be the president, you were opposed to an affidavit for the period when you were the president, Mr. Zuma, Mr. Mabandla for his period, Mr. Zuma, and now Mr. Ramaphosa for the respective periods, and will present a combined narrative of what has happened through the various administrations because of the stick that must be wielded if it's found that there's been a breach of constitutional obligations and oaths by the parties concerned.
yes. But what can you imagine, and here I'm putting the extreme, if I was here arguing for President Zuma, and you say, well, President Ramaphosa's counsel will represent you, where you'll be a witness, and publicly reported 9 wasted years. But the simple point is that, as the court says, there may be no confluence of interest. When somebody is arguing for the current administration, they say we've done nothing wrong. And when they say the previous administration did something wrong, the interests may not be aligned. That's the first. But the second is not an answer to say to the party, you have 2 alternative remedies, you've selected the first one. Well, we are not giving you the first one because you have the second one. No. That we could, all things being equal, if the government was interested in using our evidence, firstly, and that government was opposing, secondly, which it withdrew the opposition and now wants to reinstate, who knows whether it will reinstate or not.
But factually, it's not taking issue with the matter. So it's
At
effectively for the moment.
For the moment,
It's
yes.
acquiesced.
At the moment,
Which is not your client's position.
absolutely. That's the first, that's the point. And then this and as we understand, and my learned friend will find the reference, the government does say it's not going to speak on behalf of my client in the application at paragraphs 005-26, paragraph 26.1, and paragraph 26.2. It says, the reason for 26, the reason for reinstatement appears from what I say elsewhere in the affidavit. In addition, it is necessary to reinstate opposition because 26.1, currently the facts relevant to interference and collusion, particularly relating to applicants' TRC cases, have not been established. 26.2, there is no credible allegation of interference in any of the applicants' cases or the case of another person. As for collusion, there is no clear allegation of collusion. There are allegations of delay and failures to prosecute, but no allegations that these steps were not taken as a result of interference by a person. Sorry, I may have stated it very strongly, but what they really mean is their statute is the applicants have not made out a case of collusion and interference. But I just took the court to where we say they make those allegations in relation to my client, and my client wants to deal with those. So the government might take a legalistic approach, which is what 26.1 and 26.2 reflects.
Well, 26.8 has the answer.
26.8 says,
It says
until
the Commission has concluded its inquiry and they find the fact that it was inappropriate and improper to argue unlawfulness and constitutional damages in the application. So the present government wants to keep its powder dry.
Absolutely.
Until it sees which way, sees what the outcome is.
Yes.
Your client, on the other hand, wishes to be more proactive.
Wants to be
engage
proactive.
directly and answer squarely the allegations that have been made.
Yes. There's a second reason that that alternative is not an answer in law, is that the application that faces the court is that my clients want to intervene as a party. And the question for the court is, have you met the test for intervention? If yes, the court has no discretion. It must allow my client to intervene. Irrespective of the fact that it may later be a witness. I could be a witness for my wife in a dispute in which she is cited as a party. But if I have a direct interest, I can also say, yes, I can be a witness and I also want to be a party. So it's no answer at all to that. It's not an answer in law at all. But as we say in paragraph 16.3, they may well take the attitude that we have lost immunity as a government official. Because and it was decided in the Zuma case, DA versus Zuma, about the payment of legal costs for President Zuma for the criminal prosecution, that the state is involved if there's a public interest involved. There's a public interest in ensuring the rule of law, upholding the rule of law. If this conduct is intentional interference with the rule of law, breach of the rule of law, by stopping prosecutions, there's no public interest in spending public money to protect my clients. So, in other words, as we say at the end of the sentence, we may be exposed to loss of indemnity from liability as former government functionaries. Such a risk has far-reaching implications for our legal rights and financial interests, because somebody else, other than this applicant, might want to sue us personally for the conduct.
Well, the numbers are anything to go now.
Yes, these are huge numbers.
Hundreds of.
Somebody might have lost a breadwinner. Yes, of course. They may have lost support, emotional distress, all of those claims that are available in our law delict. So this order has far-reaching implications for my clients. We are not suggesting that this court is going to hold my client personally liable, which is what they are suggesting. We are suggesting that the order is the gateway to that possibility, that risk. And so my client must be there to protect himself and herself against those risks.
Otherwise, you face the same situation that you had here, where untested allegations are then presented as fact.
Yes.
Uncontested allegations.
Uncontested.
Untested and uncontested. Presented as fact.
Yes.
From which liability is then said to have been established.
Yes. So they say repeatedly...
I mean, it's a muzzling effect.
It's a muzzling effect, yes. They say the court in Rodriguez made damaging findings about interference. We said nothing. They forget that if we had tried in Rodriguez, they would have been able to argue better the Zuma position, that NDPP is a Zuma, that we're just a witness. The case doesn't turn on our facts, because he's saying he's going to suffer injustice because of the delays, and there must be a permanent stay of prosecution. But here, the context is different, and that's why we are before this court. And finally, we say in paragraph 17, the allegations made against Ms. Mabandla and I, if upheld, albeit false, will unjustifiably breach our rights. That's the development of the common law. Let me leave that for the moment, not to confuse matters. And then our Lord will see at page 00, I'm not going to elaborate again on everything, but 004-43, again, the applicants come back to the reasons for seeking intervention. They say at 35, I repeat that I have stated above, what I have stated above in summary regarding our interest and substantial interest in the subject matter of the main application. What I say below does not detract from what I have already said. Ms. Mabandla and I beg the court's leave to intervene in the main application to protect at the very least our respective right to dignity, which is protected by Section 10 of the Constitution, and to have our dispute of the Kalata applicant's serious and damaging allegations against us determined fairly in accordance with Section 34 of the Constitution. This we intend to do by challenging the tarnishing allegations against us that underpin the Kalata applicant's request for a declarator and for constitutional damages. Permitting us to place our respective versions before the court would add to the body of evidence that will have to be evaluated and tested in order for the court to determine the true factual position, apply the law to the correct facts, and thus issue the correct outcome. So it impacts the outcome in the circumstances, as well as appropriate relief, impacting the relief, duration, and the like, including that regarding the establishment of a commission of inquiry now has been established. Absent our versions, the allegations in the founding affidavit would be taken as given. There would be no contrary version before court. There would also be no other opportunity to challenge the Kalata applicant's version, including by way of appeal. So that's the Muslim. And then they go on to set out in brief the evidence that they want to present, but in summary only, because they will set that up in fully when they are asked to intervene. They reiterated this position in reply, my lord, when they are told they are just a busybody witness who wants to come and set the record straight. And they then come back at page 004-124. They say there's no relief against the interveners, and they only want to challenge tarnishing allegations. Then in reply we say at paragraph 34, 004-124, rather we seek leave to intervene because the relief sought by the Kalata applicants is expressly predicated on allegations of unlawful conduct purportedly committed by us and other state officials during our government tenure, allegations which we intend to dispute. These allegations have to be determined by this court to grant the relief the Kalata applicants seek. That is the only reason why the Kalata applicants made the allegations which they have not withdrawn. They cannot conveniently attempt to disavow this now to deny us a fair hearing. Our purpose is to demonstrate why, insofar as the conduct is attributed to us, the applicants are not entitled to the relief that they seek. It is evident that we therefore have a direct and substantial interest in the outcome of these proceedings. As we submitted, the relief does do something to our rights. And we carry on in that. But that's the basis for the intervention, and we submit with respect that the intervention should be granted on the common law position as articulated in the confirming way, which is firstly direct and substantial interest in the very relief which implicates our conduct, and the duration will be impacted by our evidence, firstly, and secondly on the basis that the allegations of which we complain and which we want to respond to and raise a dispute against to be determined by this court in order to grant relief. And on that basis, the intervention application should be granted. The development of the Commission of Inquiry, my lord, has already kind of telescoped whether the Commission of Inquiry is an answer to our application for intervention. But it is not an answer, because the answer is whether we made our case, but also the findings of the Commission of Inquiry will not be binding on this court, and the court will still have to make the determinations relevant to granting the relief they seek. My lord, I'm not going to spend a lot of time on the Libya situation, on the development of the common law, which was discussed extensively in the Libya judgment. There the court said, if the witness is simply coming to correct adverse findings, there is no basis to grant intervention, and that there is no basis to develop the common law to recognize that situation, and listed a number of difficulties that would raise. But that is not the way the situation. Our development of the common law is only if, in our circumstance, we met the weighing test, but the court still denies us intervention on the basis that we don't meet the common law. So in that case,
given an opportunity to make sure that the court doesn't make an incorrect finding.
yes,
Justice, that courts don't make findings based on half the story, as it were. But the court, when it makes a finding, it becomes a fact, and the public can rely on it.
yes.
The requirement for that is that all the relevant information is placed before the court.
Yes.
You can't control what is put before the court. You control findings and outcomes. That's usually the nub of
Yes.
that. Even if the test isn't satisfied, the bigger issue here is the complaint that if a finding is made, it may well be an incorrect finding.
Yes.
I don't have to decide whether it will be incorrect or not. That's not before me.
It's
But-
in the,
but if there's a risk that a court will be misled into an incorrect finding because direct and relevant evidence which was available wasn't put before it, that would be a failure of justice.
That would be a
And then
failure.
That would then, you say, militate in favor of the development of the common law if I find that you don't meet the test.
Yes, but our submission is we meet the test both at the level of just legal interest and legal interest as articulated in Wayne and Lear judgments. And so we would submit that the court should grant the order for intervention with costs of 2 counts. So those are submissions. I'm just checking if there's anything. They have asked for punitive costs against us if we fail. We submit, Malud, that what Malud can see, this is a novel issue.
Is that perhaps you can address that question
In reply.
in reply once I've heard from
Mr. Justice, there's a conclusion. Thank you. Those are submissions.
Chesterton, it's almost 11:05. Would suit you if we took a very clear journey and you can start.
That would be continued.
Let's adjourn until 11:20. Call the adjourn.
Keren, Pak.